It was never entered as evidence, as an exhibit, and therefore it's not part of the court record?
That's what it sounds like they said. We obviously disagree, and I believe the Court of Civil Appeals disagree. I think they clearly found that if it's a part of the decision-making process of the court and considered by the court in making that decision, and it was clearly reviewed by the court that morning in the hearing, and obviously was part of the decision-making process. He specifically requested to view it. So yes, as part of the decision-making process, it's a court record, so that part of the order we obviously disagree with.
If the court stands by its position that it's not part of court record, will you try to get this video again from the city?
I believe that we would go through all options that are available. I can't, without speaking with the client first, have to pull back on that a little bit, but we would certainly pursue all options available.
How does this work? Why did this not go to the court clerk's office in the first place?
Well, we believe it should have. Once the court essentially ordered that the video be played, or ordered the city to bring the video to the court for viewing that data, that we believe it should have gone to it. You know,
Something doesn't smell right.
No. The court obviously doesn't take that position, but the problem is the court in directing the video be brought, then played the video in open court, posted an order on the doors of the court prohibiting anybody from bringing their cell phones or other video recording devices into the courtroom. So it was obvious it was being played to the public at large. So in my mind, that's a court record, and I think the Court of Appeals found the same thing.
What's the bigger issue here? That's not just a Joe Mixon tape. What's the bigger principle here?
No, this long since being about Joe Mixon. It was no longer about Joe Mixon after October 30th of 2014 when he walked up here and entered a plea. There's a couple of things it is about too, but at the end of the day, it's about the public's ability to view all the documents that the decision-making bodies had in front of them when the University of Oklahoma decided to grant the 1-year suspension, when the district attorney decided to mete out the punishment he did for the offered plea. Those things are all done. What's really left is for the public to be able to examine all the information that's available and make their own decision and determination. Was the University of Oklahoma right? Was the district attorney right? That's the purpose of the Open Records Act, to have an informed citizenry so we can make decisions whether or not we agree with what public officials are doing.
You think this could set a dangerous precedent? You know, if this video is never released, it's going to be like, well, what's the next video that's never released?
Oh, it absolutely is. This is part of a much bigger picture. As you recall, when this came up, we were starting to deal with the body cams and the dash cams, and those are all still in play. So absolutely, this is part of it.